Hi, Leo.
May I please, your lordship? I beg to mention two criminal appeal from jail, my lord, to come up on Friday for admission, my lord. Maximum.
May it please, my lords, I beg to mention IA, my lord, for correction of the address, my lord, in a matrimony for tomorrow, my lord. I am deeply aware.
May I please, your lordship? Your lordship, I beg to mention one criminal appeal for listing in orders column, lordship. Can it be on Friday, lordship?
May I please, your lordship, with the consent of other side, I beg to mention item number 24. Your lordship, the matter may be taken up after 1 week. Senior is out of station, your lordship. D. Saraf. D. Saraf. No doctor. Mr. Next week. Obliged, my lordship.
Please, your lordship, with the consent of the other parties. Yes. Next week.
RR question.
May I please, this? Lordship. Please, you know, two. Obliged, lordship. Condon. Delay has been condoned, lordship. I have filed a miscase. Delay has been. Obliged.
Posting.
The letter dated so and so issued by the secretary shows that Mr. C. Goswami, has been appointed to the registry. Then put here, Mr.
PK Google.
P.K. Gogoi appears for the appellant. This appeal has been filed against the judgment dated 10/9/24, passed by the special judge bracket Poxo, Silchar Kachar. In special Poxo case number 48 of 2023, arising out of Lakhipur PS case number 134/2020, by which the appellant has been convicted under section 4 Poxo and section 450 IP. Admit the appeal, call for the TCR, issue notice returnable in 4 weeks. Mr. R. Kaushik, APP appears for the state. Appellant to take steps, appellant to submit a soft copy of the appeal to the office of the PP, who shall thereafter forward the same to the OC of the concerned police station, for serving notice upon the respondent number 2. List the matter after court. Then in the IA, you write,
I is also bail pair lordship.
in the IA, you write, Mr. R. Kaushik, additional PP is granted 4 weeks' time to file written objection to the application under section 430 IPC. 430 BNS.
Six.
Right. Item 6, you write, this is an appeal. Now, Mr. PK Gogoi is here again. It's different. Just write, this is an appeal against the judgment dated 9/6/2022, passed by the additional session judge cum special judge bracket Poxo Hipsagar in special Poxo case number 22 of 2020, arising out of Hipsagar PS case number 276 of 2020, by which the appellant has been convicted under section 6 of the Poxo Act. Admit the appeal, call for the TCR, issue notice returnable in 4 weeks. Mr. R. Kaushik, additional PP, appears for the state. Appellant shall take steps for service of notice, appellant shall submit a soft copy of the appeal to the office of the PP, who shall forward the same to the OC of the concerned police station for issuing notice to the respondent number 2.
I am appearing for respondent number 2, Your Lordship.
How? How are you appearing?
As legal aid counsel.
Where is your letter? Appointing you as legal aid counsel.
Yes, it's there, Your Lordship.
Where?
Yeah.
Where?
Copy, Your Lordship. I have the copy. It's in the court number 4. I gave the filing letter.
This has come the first time, madam.
Whatever I said.
There's IA.
Once it came, Your Lordship.
Okay.
Once it came. This is second time, Your Lordship.
No, not in the main appeal. Okay. Then you cut that part, huh? That it's a soft copy particular. Ms. K. Fukan, learned legal aid counsel appeals for the respondent number 2. List the matter after 4.
Okay.
Mister? What is your name?
Yes, Ali Lordship.
Mr. S. Ali appears for the appellant Biki Thapa, B-I-K-I, Thapa, who has been convicted along with 4 other co-accused who are not appellants in this case. Pushpa. They have been convicted by the court of the additional session judge number 2, Kamrup M at Guwahati in sessions case number 99 of 2016. Under section 447/34, 325/34, 30 and 302/34. Admit the appeal, call for the TCR. Mr. R.R. Kaushik, APP appears for the state. This is the matter of the following.
There's an IA Lordship.
In the IA, Mr. R.R. Kaushik is granted 4 weeks time to file written objection to the application under section 430 BNS. This is the matter of the following.
Highly obliged.
But this appeal is against rejection of a bail by order dated 7/7/25, which your lordship will find it is not.
So what is to be done now?
Now, notice has to be.
Okay. Mr.
US Bora.
U.S. Bora, learned counsel for the appellant, who submits that the order dated 7/7/2025 passed by the
Special Judge. Special Judge Nia.
Judge NIA, Assam Guwahati, rejecting the bail application of the petition appellant to be set aside. Issue notice returnable in
3 weeks.
3 weeks. Sir KD Chaudhary, standing counsel NIA is present. That's all.
See, can you
This is the
fix the
matter.
date?
Huh?
Can you fix the date, Lordship?
This is the matter now.
Lordship.
Yes.
Obliged.
Bill against conviction, my lord. Yeah, my lord, the kindly see the FIR, my lord.
Love affair.
Club FIR, my lord. And the present appellant, my lord, he is in jail for more than 2 years, my lord.
Yes.
Kindly see the FIR, my lord, there is no indication of this section.
Otherwise,
Four of the
Pokto is there.
Page 12. Page 12.
Page 12, my lord, is the FIR, my lord.
But then why did you upload all those videos in social media?
There is no proof, my lord.
Learned counsel for the appellant submits that the appellant has been convicted under section 376 bracket 2 IPC and section 6, POXO Act.
No, only 376 2, Lordship.
Are you sure?
POXO has been removed.
Huh?
POXO is not there, Lordship. Only
Let's see. Oh. Okay, 376 2 IPC.
376.
Admit the appeal, call for the PCR. Mr. R. Kaushik accepts notice on behalf of the state. Huh? List the matter after 4 weeks.
Much obliged.
Please, your worship. It's appeal against conviction.
And Mr.
D. Boraman.
D. Bora learned counsel for the appellants. Appellants.
Appellant.
Appellants submits that the judgment dated
29
29/8/25 passed by the court of the additional session judge, Dubri, in sessions case number 319 of 2008, by which the appellants have been convicted under section 302 and 149 IPC. Please set aside. Admit the appeal, call for the PCR. Mr. R. Kaushik, APC accept notice on behalf of the state. This is the matter of the 4 weeks.
There is an I also.
Mr. R. Kaushik is granted 4 weeks time to file his written objection to the application and the section 430 be NSF. This is the matter of the 4 weeks. Huh?
Obviously.
Lordship, order dated 25/3/2025. May I kindly forward maybe?
Service is complete, your lordship.
Last occasion, my lord, 25/3/25, my lord.
Yeah.
Observed that, my lord, the completion of services of recent origin, that's why courts.
Next one, any day, man.
Give a date.
Date, man.
Forget that. No, we'll dispose of the entire, all the appeal.
My lord, till disposal of the appeal.
So we'll dispose of the appeal today. Today we'll dispose of.
Then you said that it is up to your lordship, my lord. There are several occasions for hearing matter was.
So we are ready today.
As your lordship, please.
I don't think we'll do hearing after.
All the accused appellants have been released on bail earlier occasions
So now we might have to cancel all their bail applications.
during pendency of this, of those appeals.
Cancel all their bail applications.
My lord, that is why we have filed this, because of, except this person, Nirmal Pal. All other accused appellants were released on bail. And that is why.
So you don't want to have a hearing on the appeal, you want only the
Yes,
bail.
I am also, if your lordship please to hear us, then I am ready to hear, argue the matter today itself or next date also.
Okay, why do you on bail on what ground?
Bail, my lord, ground, my lord, he has been detained since the date of, last 10 years, my lord, detained. And earlier occasions also during investigation, he was in jail, my lord. So,
Okay, then what is the ground for bail? Yeah, all others have been granted.
bail, my lord,
Any witness see, there was some witness, eyewitness with regard to his action. Then
there is only one eyewitness, my lord. That is
one is
informed.
enough.
Only one eyewitness. That eyewitness persons has not been supported by any other witnesses, man. In this case, that is our ground for this appeal, man.
But where is the ground for bail?
Well, bail, a long detention may kindly be considered, as earlier your lordship was pleased to consider the long detention. About 10 years, he has been detained in jail, my lord, continuously.
But these appeals are of 2016.
Yes, my lord. since then he has been detained, 2019.
We'll dispose of the appeal.
Yes, yes, and if your lordship
Yes,
is,
the appeal, my lord, my appeal is short, my lord, only one person. I was not named by any other witness except one witness.
But you see, this is 302-2034.
34 is there, man.
Then,
But I did not participate, my lord. None of the witness,
you did not participate.
no, I was not naming the FIR.
So what? Just because you're not named, FIR is not an encyclopedia.
Name my lord.
Huh?
The other witnesses also did not name
They did not name you.
my.
You were not in the place of the occurrence.
And I was there, my lord, but my participant is not there, my.
You did not hit.
No, nothing.
So what? But then you must have some other role.
No, my lord. It is between all members of the Paul family have been made accused, my lord, in this case.
But Supreme Court says that it doesn't have to be, you don't have,
Before says, my lord, some
you don't have to be a part of the person who assault.
others, but this is a case of 149, man. This is a case of 34.
That's what.
So participation is necessary.
No,
Yes, man.
34 participation not necessary.
So any act which attributed
No, participation not necessary.
and your lordship.
If you are the one who are standing and preventing from any
No,
aid
that-
taking,
That statement is not there, man. And injuries are all cut injuries, my lord. So cut in, and they have specifically said who has caused the injuries, man.
My lord, in this case, Shibupal is the main culprit who gave a
blow.
blow, my lord. And he is a minor, and many of them have been declared minor and juvenile.
Bail culprits have been declared minor. That is the.
That is the rule. And he is facing trial in the juvenile.
If your lordship hear the matter, we can proceed, my lord.
We are ready.
It's up to. Because
You see, the problem is this is 2016-17 matter.
yes, man.
Now, if we grant you bail now, you are not going to have hearing. You are going to avoid having a hearing.
No, but in that event, your lordship may fix a specific date,
The
but
date is will fix today. Man.
Today's will fix.
very true, but my friend has also.
You want to, you will fix.
Your lordship has said, that, why don't you file an application for bail? That's why my friend has filed the bail.
Oh,
at least for some days, my lord, till hearing of the,
Someday he will come.
When do you want the hearing to take place?
till,
No, okay. Supposing we grant you bail, when do you want the hearing to take place?
My lord, and there is one thing, my lord. Since my other friend has already filed an
Yeah.
IA, so I am also duty bound to file an objection. My lord.
at least for 2 weeks
But-
only.
389, I have to file my written objection.
He wants to file 389 objection.
So any
Yeah,
short date
duties-
may be fixed, my lord, matter can be disposed of in my humble service.
Lordship has granted bail to other accused person also on this parlance of long detention.
Yes, there also we have filed objection.
8 accused persons, out
But
of
the
it.
objection, honorable court has granted.
It's a
No,
court
no, that
may-
is mandatory. We have to found by the law.
Mandatory, you can file. You can put some.
with certain conditions, my lord, at least for 2 weeks. Let him peacefully in his residence at least some days, my lord.
After that, you will not come for hearing. You will have some problems, medical problems.
We
Definitely
want
will
to
appear.
up the burden, my lord. Long burden we are carrying now. Exactly. From 2016, we are like, for almost 10 years.
Actually, it's
টাউন উকিল আছে না, যেমন টাউনটা কিন্তু যাবে।
it's not the same. It's next week, this will discuss. One of my commission.
Maximum we don't know. একটা দিছে। যে মানে মৃত্যু আছে, আপনার মৃত্যু আছে। এই দুজন নাম ভান্ডারের লোক খাওয়া দিতে ছিল। I leave it to your lordship, my lord.
Okay, you find it, how much time? 10 days?
Within a week.
Okay, right. Mr. In this item 27, Mr. R. Kaushik is granted 10 days time to file an objection. This is the matter after 10 days. Take this matter along with item 20, 20 to 23, huh?
You fix for hearing, my item number is 21 now.
We'll fix everyone. When do you want? This is the matter on 11th, 12th.
Any date in the month of first week of December?
Oh, Barbara. Right?
November, man.
November last week.
We want to finish it off, my lord, actually.
13th. Which one?
13 November.
Single that PK Goswami, no?
RR Kaushik.
Huh?
That's what we got.
That oil metal.
Objection removed. 28th of November.
Okay.
20. 20.
20.
November.
Okay, 20th.
That's all. I think 26.
Oh.
Stop it.
Yes.
26.
Yes, Your Lordship. So in this case, Lordship, the appellant Lordship was convicted. There are three appellants, Lordship, convicted under section 302, 304B and 34 IPC, Lordship.
302, 30,
304B and 34 IPC, Lordship.
Well, here, before my learner friend starts, my lord, this matter came up in the subject list, so I could not go through yesterday, but I will try to assist, my lord.
I think she gave her, a dying declaration.
Lordship. Lordship.
Bright burning.
But 90 to 95% burn injury, Lordship.
Difficult.
Lordship.
Is it difficult or easy for you?
Lordship, dying declaration, the prosecution did not examine the medical officer, Lordship, whether she is able to speak at the moment, Lordship.
That's all.
Lordship. And three appellant, Lordship, one is husband, father-in-law and mother-in-law.
So,
Lordship.
let us see.
Lordship.
This Tahar Ali is what? Tahar Ali is the
Ali is the father, husband,
Madam,
Lordship.
Tahir Ali is the husband.
husband.
Yes. And the rest are Madam father. Number 2 is a father. Number 3 is a mother of the number 1 of accused number
1, 2 is father.
2 is a father of accused number
No.
1.
Father-in-law.
Father-in-law.
Father-in-law. And
number 3 is mother-in-law. Mother-in-law. And number 4 murder here not. Total 4 accused are named in the FIR. 1 against them, against another FR was given.
what happened to that?
No, that FR was submitted against him. He was not charge sheeted.
Not charged.
Not
Who is that for?
He is my brother.
Oh, brother of
Brother of the husband, accused number 1. Sir.
Anyway, so that is not an issue here.
No, he is not before the lordship because he is already dead now.
Okay, so let us go from page 4.
Yes. Now your lordship will find total 4% as I have stated, my lord. Then page 5. FIR, my lord, date of occurrence is 27. Yes, page 5, my. Humble submission is that the informant daughter Miss Noor Asma Begum was socially married to the accused number 1 some 9 months ago.
Yes.
After her marriage, the accused number 1, instigated by the other accused persons, assaulted her by demanding dowry and drove her away from his house. Several times the informant settled the matter with the help of the public and gave them money to the best of his ability. Around 7:30 p.m. on 27/7/16, accused number 1, together with the other accused, here we come, my other father and mother come, assaulted informant daughter and set her on fire by pouring kerosene oil on her, resulting in 90% burn injury. Later, the accused persons took her to GMCH. Learning about it, when the informant went to the hospital along with his fellow villagers, namely Amjad Ali, Faizul Ali, and the PW9, PW6, and PW-7, and asked her about the incident. She said that the accused number 1, along with the other accused person, assaulted her and set her on fire by pouring kerosene oil. Thereafter, around 3:50 a.m., informant daughter might have died. This is the case, my lord. That was occurrence 27, and this FIR was filed on 28. And total 10 PWs, my lord. Charge sheet, my lord, 302, 304 also, my lord. Conviction under 2 heads, 302 life and 304 7 years, 304B.
34 not there.
34 is there. 34. But that together has come, my dear. But you also will take a main appeal or IML?
I'm taking the main appeal.
Oh, main appeal.
Main appeal.
Yes.
So let us go to the PW1.
Yes.
Informant.
Now PW1 is page 9. I am the informant of this case. I know the accused Tahir Ali, Pandit Ali, and so and so, so and so. Tahir Ali means husband, Pandit Ali means father, and Hasina, the mother. Deceased Noor Asma Begum was my daughter. The occurrence took place on 28/7/16. In the FIR, it is given 27, my lord. Here it is 28, it's saying. About 9 months back from the date of occurrence, my daughter Noor.
That's typographical error.
Maybe.
I think.
Yes.
What does the record say?
The silos and actual date of occurrence.
I think this is the
original copy.
This is the, now we are giving original one.
no, this is the original.
Silos.
And this is typographical mistake.
Yeah. So the FIR because at 27. Now we have to 28. Days of occurrence.
Because occurrence, because he died on 28/7.
Died 28. So.
Yes, carry on.
Occurrence 27, yes. 27.
28/7.
28/7.
Because
No, it was the same. Original record has some difference.
This is the original.
Anyway, my lord, that is getting there. That is not, I don't think that. Occurrence took place once about 9 months back from the date of occurrence. My daughter Noor Asma Begum was married to accused Tahir Ali by solemnization of a social marriage. After 3-4 months of their marriage, my daughter was subjected to physical and mental torture by the accused persons. The accused person demanded motorcycle and cash money from her. Accused Pandit Ali, that is father, my lord, and Hasina mother are the parents-in-law of my daughter. After marriage, my daughter used to stay at the house of the accused persons. But when she was subjected to torture by the accused persons in demand of money and article, she used to visit my house and reported the occurrence to me. Then the accused persons, accompanied by their relatives, villagers, came to my house, brought back my daughter. One Raj Ali, who is the co-villager of the accused persons, informed my co-villager Idris Ali on the relevant night of the occurrence that my daughter was suffering burn injury and she was laid on veranda leave. But here, kindly note, my lord, that Raj Ali and Idris Ali not examined. Kindly note, my very important vital differences. That my daughter was suffering from burn injury and she was laid on banana leaf. After getting the information from the Idris Ali, I accompanied my 4 other co-villagers. Straightway went to GMCH, Guwahati. At around 1 a.m. on the relevant night, we found our daughter inside the toilet of GMCH. She was in the toilet now. Her whole body was wrapped with white cloths, covering her burn injuries. We brought her and laid her on the bed. She was asking for water. On being asked, she stated to me that the accused person, namely Tahir Ali, Pandit Ali, Banu Bibi, and younger brother of Tahir Ali, that person who was discharged by.
Discharge?
Not charged, not charged, right. Had set fire on the body. The medical staff of the Guwahati Medical College, Guwahati, lifted her on the table for conducting ultrasound, but she died immediately around 3 a.m. Before ultrasound examination, postmortem examination on my deceased daughter was conducted at GMCA. Thereafter, the dead body was brought to my house and we performed her last rites. I made telephonic information to the police. Soon after the expiry of my daughter, I lost the formal Azhar as so-and-so on the same day. Police recorded my statement during the investigation. The Azhar is written by the scribe under my instruction. I put my thumb impression on them. I am an illiterate person. Now cross mine. Azhar is logged by me at so-and-so in the evening time. My thumb impression on the Azhar was obtained in Guwahati. So FIR is written there and thumb impression here, go to it. And the FIR was filed there at that place. At the time we arrived at GMCH on the relevant night, my daughter.
She says that I made telephonic information to the
Police.
telephonic.
At the time we arrived GMCH on the relevant time, my daughter was asking for water and she was lying on the latrine, that is my toilet. Myself, Amjad Ali, PW9, Amjad Ali, then Shahar Ali, PW7, Faizul Haq, PW6, and Noor Islam, PW8, lifted our daughter and brought her to the bed. I forgot whether I stated before the police that my daughter, wrapped with white colors, was lying in the latrine of GMCH and we brought her to the bed. It is not a fact that in my previous statement before the police, I did not state that Amjad Ali, Shahar Ali, Faizul, Noor also accompanied me on the relevant night in GMCH Guwahati. We did not find our daughter in a sound state of health. So she was in a deteriorating condition. Police asked me about the occurrence before lodging the formal Azhar. It is not a fact that in my previous statement before police, I did not state that the accused person used to torture my daughter by demanding cash and motorcycle. It is not a fact that in my previous statement before police, I did not state that my daughter used to visit my house after she had been tortured by the accused persons, who also visited my house along with their co-villagers to bring back my daughter. It is not a fact that in my previous statement before police, I did not state that Raj Ali, co-villager of my accused persons, informed my co-villager Idris Ali about the occurrence involved in burn injury on the relevant evening. It is not a fact that my previous statement before police, I did not state that the medical staff lifted my daughter on the table for conducting ultrasound. Your Lordship, kindly note here, my lord, because RDX has stated that the medical staff, they have brought her from toilet to the bed, my lord, for ultrasound.
How is that relevant?
No, relevant because,
She did not deny that she was having burn.
yes, that is admitted. So far, burn injury is concerned.
Then
But one day who brought her to bed, he said this person, and RDX he said, my lord, that, anyway, but that is also important, my lord, because some dying declaration, that's why I am saying, my lord. It is not a fact that I am falsely deposing that my daughter stated me that the accused person set fire on her. Ayuddin is the son-in-law of my elder brother. Ayuddin on the relevant evening made a telephonic call to me, but I cannot recall what information Ayuddin had given to me over telephone on the relevant evening. It is not a fact that I myself and my daughter over the telephone that she should commit suicide. It is not a fact that I myself asked my daughter over telephone that she should commit suicide and I would teach a lesson to the accused persons. It is not a fact that my daughter committed suicide by burning herself and the accused person never set fire on her. Then you will also find relatives that PW2. PW2 page 12. Relative, my lord, I do not know the informant of this case. I know all the accused persons, Tahir Ali, Pandit and Hasina Bibi, standing in the door. They are my own relatives. Deceased Noor Asma Begum was the daughter of Noor Islam. Noor Asma was married to Tahir Ali. After their marriage, quarrel developed between them. I heard that Noor Asma used to visit her father's house and then accused Tahir Ali and his relatives brought her back. Within 1 year of her marriage, Noor Asma died due to burn injury. After her death, Noor Islam lost the case. Police came and recorded my statement. Police seized half-burnt sari, 1 half-burnt blouse, 1 plastic containers of kerosene oil in my presence by preparing a seizure list, so and so. I myself did not see any quarrel between Narsma and the
okay, so basically it was hearsay evidence.
Yeah, hearsay.
Okay, then for 3 also nothing much.
He also did not, only my daughter. Now, 3 did pay a postmortem.
Okay, that's all. So
Yeah.
how does it?
Yes,
So then 4 also not relevant.
yes, also not relevant.
Then
Mobilizer, hostile. 4 also hostile one. 5 hostile. Mobilizer. Now 6. Only 6. But it is based on PW 6, 7 and 8 and 9. Now page 6, madam. PW 6. Is a co-villager not related, madam. I know the complaint Noor Islam, I know accused Tahir Ali, Pandit so and so, so and so. Occurrence took place about 5-6 years back. Noor Asma was married to Tahir Ali about 9 months prior to the occurrence as per social customs. After 1 month of their marriage, Tahir Ali and Pandit Ali demanded cash and articles from Noor Asma and harassed her. Therefore, village sitting was held where I was also present. The matter was settled at the village sitting. Noor Islam, who is the father of Noor Asma, on the relevant night of occurrence, went to my house at about 10 p.m. and requested me to accompany him with my motorcycle to Harobala police outpost. I asked him what had happened. He stated to me that Tahir Ali set fire on Asma. He informed the incident to the in-charge of it. Thereafter, by hiring a car, we straightway went to GMCH Guwahati. I saw Noor Asma was wrapped with a white color cloth in an emergency ward and her body was burned. So he is saying about emergency ward, not in the toilet, madam.
no, but then after he said the moment she was going to
The moment she was going to the toilet, nearby the emergency ward, that you also see whether in a position to go to toilet, more than 90% burn injury. You also can. Initially they said they found her in the toilet. This they are saying, father is saying, found in the toilet. Now saying that moment she was going to the toilet nearby emergency ward, I asked her how it can be. They found her in the toilet. Here he is saying that when he was going to toilet, she was going to toilet, he had that does not. Quite contradiction, my lord. And this is the vital point here. The moment she was going to the toilet nearby the emergency ward, I asked her what happened. She stated to me that Tahir Ali had set fire on her by pouring kerosene, while as per direction of his father, I was waiting on the ground floor. After 15 minutes, I heard Noor Asma was shifted to the upper floor of the GMCH for her examination, and she was admitted. On the same night at around 3-4 a.m., Noor Asma succumbed to her injuries. On the next day, the dead body of Noor Asma was brought to her father. So at the time of incident, Noor Asma was pregnant, which she disclosed to me. Doctor did not find matter about the pregnancy. Nothing found. Now, my house is at a distance of about 3 kilometers away. You all kindly note, this is also important, man. Whether he is reliable or not. 3 kilometers away.
So,
Villagers are there, my daughter. His daughter burned.
so.
His daughter burned, he could have taken somebody from
No,
the.
no, he'll take his best friend or someone who is close.
All my, can he go to 3 kilometers away or he?
No.
Uh,
I know.
they are in emergency.
3 kilometers is not very far.
My lord, we should be realistic, my lord. Whether it is possible, I am only on that, my lord. 3 kilometers away, my lord. My villagers are there in the village, my lord. My house is distance about 3 kilometers from.
How did the deceased get burned? According to you, how did the deceased get burned?
No, that, my lord, it is not my question, is my lord.
I'm asking you, how, according to your information,
313 I have given, my lord, because of her own, my lord.
how? She burnt
She
herself.
was some sentimental, emotional. Actually, father is responsible for that, my lord.
So she burnt herself.
No. My lord, your lordship, of course, it is really, everybody is concerned about this type of matter. But it does not mean that everywhere, my lord, we have to believe that my husband has done. Sometimes it happens. I am not denying that we are getting it. We are also in the human society, in the society, man. Yeah, it happens, but I'm not denying at all, man. But every case, here 313 there is explanation, my lord.
Okay.
I'll come to that, my lord. Or should I take to that page first,
No,
my
no,
lord?
carry on, carry on.
Yes, ma'am. It is 3 kilometers from the house of Tahir. It is not a fact that in my previous statement before police, your lordship, I did not state that Tahir Ali and Pandit Ali harassed Noor Asma by demanding creation articles. So it is none. It is not a fact that in my previous statement before the police, I did not state that a bichar was held on the demand and harassment of the accused to Noor Asma. Only one thing you can keep in mind, but total 9 months. In the 9 months, how many bichar, whether bichar was held or that
Is he, so this person, is he related?
this accused.
No. This
No.
PWC.
He is saying he's co-villager, not related.
So he was a part of the bichar also.
That might not what he is saying, Madam Bichar.
Yeah.
On the same night, where Bichar,
He says here, in the para 2 of his examination in chief, a village sitting was held.
Noor
When
Islam,
I was present. The matter was settled at the village. So there was an issue.
no, so now see, you almost kindly see whether he was Bichar or not, my lord. Cause kindly see, my lord. Now, let us see, my lord. It is not a fact that in my previous statement before the police, I did not state that Noor Islam had visited my house on the relevant night of occurrence and requested me to accompany him in motorcycle to so-and-so. And he stated that the accused Tahir Ali set fire on his daughter, Noor Asma, by pouring kerosene oil. He has gone 3 kilometers, my lord, to bring that person on motorcycle. It is not a fact that in my previous statement before the police, I did not state that I had asked Noor Asma while she was going to toilet from emergency ward as to what had happened. It is not a fact that in my previous statement before the police, I did not state that Noor Asma stated to me that the accused Tahir Ali set fire on her by pouring kerosene oil under the direction of his father. It is not a fact that I did not state before the police that Noor Asma stated to me that she was pregnant. It is not a fact that I never, Noor Asma, that I never before her death. It may be that I never met or something. Something is omitting here. Then, my lord, page 22. He is the own grandfather of the victim. PW7. I know the informant Nur Islam. I know accused Tahir Ali. Deceased Nur Asma Begum was known to me. In the year 2016, one night at about 9 p.m., informant Nur Islam called me to his house and asked me to go to Guwahati along with him. Thereafter, informant, elder sister of Nur Islam, and nephew of Nur Islam, went to GMCH. You will kindly note who have gone. Thereafter, informant, elder sister Nur Islam, and nephew of Nur Islam went to GMCH. So how PW my lord 6 comes? He said he also accompanied. Especially he is saying, my lord, that in the year 16, at about so and so, informant Nur Islam called me to his house and asked me to go to Guwahati along with him. Thereafter, informant, elder sister of Nur Islam, and nephew of Nur Islam went to GMCH Guwahati and saw that 4 or 5 persons were bringing Nur Asma from the bathroom of the hospital. And she told before us that her husband, father-in-law, and mother-in-law set fire on her. Her body was wrapped with white cloths. I waited in a corner of the hospital and Nur Asma died on the late night. Thereafter, the dead body of Nur Asma was brought to Soha House of Informant. Prior to 8 months, Nur Asma got married with the accused Tahir Ali. Prior to the incident, one day I met the deceased on the road and she reported me that she is going to her parental house as the member of her in-laws were torturing her, demanding motorcycle, money, etc. Thereafter, informant filed this present case, police record and statement. It is not a fact that before police, I have not stated that at GMCH Guwahati I saw that 4 or 5 persons were bringing Nur Asma from the bathroom of the hospital. Who are those 4 or 5 persons, madam? Father, first time they have went there with these 4 persons, madam. And who are those 4 persons? Whether they are staff or they are persons or relative or who are those persons? Madam? I have not stated that the GMCH Guwahati I saw 4.
You did not question. Did you question the witness as to who are those 4 or 5 persons?
Now, you lost him to see, madam. Here they say, especially cases that he, along with informant, sister-in-law, and that 4 persons have gone there. Man. And there he is saying,
No, but this I saw 4.
no, but your lost, it is not a fact that before police, I have not stated that at the GMCH Guwahati, I saw that 4 or 5 persons were bringing Asma from the bathroom of the hospital, and she told before us that her husband, father-in-law, and mother-in-law set fire on her. Meaning thereby, my lord, that except this person, except this PW, this person, my lord, PW7, PW6 was not at all there, my what I am on, my lord. From this, it appears, my lord. And it is evident from that, this PW, that 6 was not there. Especially case that I so and so, he is the grandfather, my lord. Your loss of deceased was my granddaughter. Here, page 23. So his reminder is discarded. PW6 goes. It is a story which might have set out subsequent manner. It is not after the deceased was my granddaughter, I deposed falsely against the accused persons. Then 8, my lord. 8 is a paternal aunt of the victim. She is also not there, my lord. The special case that PW7, informant, sister-in-law, and then when they have gone to the hospital. Here, PW8, paternal aunt of the victim. I know the informant Nur Islam. I know accused Tahir Ali. Deceased Nur Asma Begum was known to me. About 6 years ago, I heard that Tahir Ali and his family members demanded motorcycle, etc. from Nur Asma and assaulted her. After 9 months of the marriage of Nur Asma with the accused Tahir Ali, one day at about 8 p.m., I heard that accused Tahir Ali and his family members poured kerosene oil on the body of the Nur Asma and set her fire on fire. Thereafter, she was brought to GMCH for treatment. And after getting the information, I also went to GMCH. Subsequently, she has gone. In the hospital, Nur Asma Begum told before us that how she got it, my lord. this person. After getting information, she have gone there. She has not gone along with them. And she said, we found him there. Husband, father-in-law, mother-in-law, Asma Begum, and told before us that her husband, father-in-law, mother-in-law poured kerosene on the body and set fire and so and so. She also told before us that she was carrying too much so and so. On the same night at about 3 p.m., Nur Asma died in the hospital. Thereafter, she was brought to the house of the informant. Now, next matter. After arriving at the GMCH hospital, I found Nur Asma Begum in the latrine of the hospital. How is it possible? It is not a fact that after arriving at GMCH hospital, I have not found Nur Asma in the latrine hospital, but at the emergency ward. The emergency ward and the latrine of the hospital are adjacent. We were not allowed to enter in the emergency ward. It is not a fact that Nur Asma Begum did not tell before us that her husband, father-in-law and mother-in-law poured kerosene on her body and set her on fire. I know the family members of the accused person. There are total 6 family members in the house of the accused person. It is not a fact that I did not meet Nur Asma Begum in the hospital. This is correct one. It is not a fact that before police I have not stated that I heard that the accused Tahir Ali and his family members poured kerosene. It is not a fact that I did not hear that Tahir Ali and his family members demanded motorcycle, cash, etc. from Nur Asma. That it was my niece. Here that I am saying that niece. So she is my own granddaughter. It is not a fact that I deposed falsely against the accused person as the deceased was my niece.
So if deceased was the niece, how can she be granddaughter?
My niece. Niece, my God, niece. Not granddaughter. Earlier one, my. 8. It is my paternal aunt of the victim. Niece one, not granddaughter. Granddaughter earlier one. Yes. PW 7. 7 is the own grandfather of the victim. And he is my own paternal aunt of the victim. PW 8. PW 9. Page 26. He is my lord maternal uncle. Maternal uncle of the victim. I know accused so and so, so and so. Prior to 7-8 months of the incident, deceased Nur Asma Begum got married with the accused Tahir Ali. After the marriage, the deceased accused used to torture Nur Asma Begum on the demand of dowry, and for this reason, she often used to visit her parental home, and the villagers set married and used to send back her to matrimonial house on 2-3 occasions. In the year 2016, one night, I heard that the accused person set fire on Nur Asma Begum and she was rushed to GMCH for her treatment. Thereafter, I went to GMCH and saw that Nur Asma Begum was lying there with burn injuries. At that time, she was carrying pregnancy of 3 months. And doctor advised for ultrasound examination, and while she was brought for ultrasound examination, she died. Nur Asma Begum reported me that the accused person set fire on her body. Police was informed, police who were informed. It is not a fact that my previous statement before police, I have not stated that after marriage of the deceased, the accused person used to torture Nur Asma Begum on demand of dowry, and for the reasons. She often used to visit her parental home, and the villagers settled in the matters and used to send back her to matrimonial home on 2-3 occasions. It is not a fact that today I have falsely deposed that after the marriage, the accused person did not use to torture Asma Begum on demand of dowry, and for this reason, she often used to visit her parental home, and the villagers settled the matters and used to send back her to her matrimonial home on 2-3 occasions. It is not a fact that Nur Asma Begum did not report me that the accused person set fire on the body. It is not a fact that in my previous statement before the police, I have I have not stated her. Noor Asma Begum reported me that the accused person set fire. It is not a fact that I have deposed falsely today, as the informant is my mother-in-law. So means victims maternal uncle. Then who remains right? Then 10. Ayo. Medical is only postmortem doctor has heard, medical doctor, other doctor not exam. Now kindly say page 28, Ayo my. Now on what basis murder? Who is the person on basis of which this conviction was made?
On the basis of the dying declaration.
Who? Dying before whom?
Before
Except informant. Except if we assume that it is correct, except informant, nobody has made up. Because all are given 7, 8, 9. They have gone subsequently matter. Somebody said when I went there, I found that she was she was on way to a bedroom, my lord. Somebody said I found while going to a toilet, on the way she told. Somebody said she was found in the latrine. Somebody said when I had gone there, after she came back, my lord. All are my lord contradictory. So how these witnesses are reliable witness, man? Now kindly cross in the IO, my lord. Just only one my lord. Page 28. 127-7, I was working in charge of so-and-so police outpost under Tamulpur PS on that day at about 11 p.m. One Noor Islam appeared in the outpost and he verbally informed me that his daughter Noor Asma Begum got married with so-and-so, and after the marriage, her husband Tahir Ali and family members subjected her to cruelty, physically and mentally demanding dowry. And on that day at about 8 p.m., Noor Asma and father family members set fire on her body. On getting, so you'll kindly note here, my lord, instead of going to the doctor, he has gone to the police. So just your lordship, police. On getting the information, I entered the same in the GD entry. He could have done it by telephonic, my lord. He could have informed by telephone, man. But here, IO is saying that he has gone to the police station.
He telephonically he did first, then he went to the police.
That is what I am saying, man. His daughter is burning. His daughter is 90% burning. Then he has his immediate duty is, my lord, delay of FIR. In that case, your lordship will have to condone, my lord. In that case, man. Because instead of going to the police station, he ought to have gone to the medical, my lord. Who has taken him to medical, my lord?
Says that he has to go first to the hospital.
You'll kindly see, man, what he is saying.
Oh, he can go where he wants first.
No, I'm not saying that he should not go to the police station. He could have sent somebody else. He could have done it by.
He could have done. He did.
I am not on my lord. So your lordship is to believe, my lord, about the veracity of.
Believe him. We believe him. We went to the police station. So what's wrong?
No, I'm not. Just conduct. I am just coming to my lord. The chief I am getting, my lord. On getting the information, I entered the same in the general diary and I was proceeded to the place of occurrence at 12 midnight. So on getting information, I entered the so-and-so and he has gone to midnight, and after informing my superior officer, I visit the place of occurrence, do the sketch map of the place of occurrence, record the statement of the witnesses. I see one burned yellow color sari, one blouse, plastic bottle containing smelling kerosene oil. Before I reached the place of occurrence, the victim, Noor Asma Begum, already took to the hospital by the villagers. By the villagers.
By the villagers. Why didn't the father-in-law and the husband take the thing?
Your lordship will find, they have also gone, madam. Your lordship will find in the already took the hospital by the villagers. On 28/7/16, informant Noor Islam lodged an FIR after receiving the entered so-and-so, and forwarded the same to the OC. Accordingly, Tamulpur is registered, entered to complete the investigation. Noor Asma Begum so-and-so. Thereafter, I sent WT message to OC, Bangagok PS, for postmortem examination and inquest of the dead body of the Noor Asma. On 29/7/16, I arrested the accused Tahir Ali and Pandit. I arrested accused Hasina Begum and forwarded her to the court for judicial custody. Thereafter, I collected the postmortem report and inquest report from the OC Bangagok PS. After completion of the investigation, I found sufficient materials against accused Tahir Ali, Pandit Ali, and Hasina, and accorded late, the charge sheet was given, ma'am. Then now to official exhibit, let us skip my lot. Now come to my PW4, that is Tamsir Ali. During investigation stated before me that last night about 8 p.m. while he was going Dalanga Chowk, he came to know that house of the Ali was burning in the fire. The house of Tahir Ali. And accordingly, he, along with other people, hurriedly arrived at his house, and Noor Asma, wife of the Tahir Ali, was lying in front of the courtyard with burn injury. PW4 Tamsir Ali, during investigation, further stated that he, with the help of the villagers, immediately sent wife of Tahir Ali by vehicle for treatment at GMCH, accompanied by parents-in-law and your other 2 persons, your lordship. Parents-in-law. That is matter appeal number 2 and 3. Along with them. Tamsir Ali, during investigation, stated before me that since after her marriage with the accused Tahir Ali, there was frequent quarrel between them, for which she also left for her matrimonial house, and after negotiation by people of both the villages, she was again brought back. PW4 Tamsir Ali, during investigation, stated before me that the police says some burnt clothes owned by injured Noor Asma and other materials from the house of the accused Tahir Ali in his presence. PW5 Sajana Begum, during investigation, stated before me that since after marriage about 7-8 months back, accused Tahir Ali used to quarrel with his wife Noor Asma Begum and assaulted her, and as a result, she left matrimonial house 3-4 times and again brought back after negotiation. PW5 Sajina Begum, during investigation, further stated before me that while she was preparing rice in the last night, she heard hue and cry, and she out from her house and arrived at the house of the accused Tahir Ali and found his wife was lying at the courtyard with a burn injury, and local people tried to douse the fire, and as she sustained injury, she rushed to GMCH. PW1 Noor Islam did not state before me that Amjad Ali, now your lordship, Shahar Ali, Faizul Ali, and Noor Jahan also accompanied him on the relevant night to GMCH. Those 8, 9, 10, 11 night. PW1 Noor Islam did not state before me that the accused Tahir Ali demanded cash money and motorcycle. PW1 Noor Islam did not state before me that his daughter used to visit his house after she has been tortured by the accused person, who also visited his house along with the co-villagers to bring back his daughter. PW1 Noor Islam did not state before me that Raj Ali, a co-villager of the accused person, informed co-villager Idris Ali about the occurrence involved in burn injury on the relevant farm. That is not important, they are not examined minor. PW6, now your lordship, Faizul Haq, did not state before me that Pandit Ali harassed deceased Noor Hassan by demanding cash and articles. PW6 Faizul Haq did not state before me that a bichar was held on the demand and harassment of the accused to Noor Asma. PW6 Faizul Haq did not state before me that Noor Islam had visited his house on the relevant night. Faizul Haq did not state before me that Noor Islam had visited his house on the relevant night of the occurrence and requested to accompany him in his motorcycle. And he stated that accused Tahir Ali had set fire on his daughter. He said that was an informant by pouring kerosene oil. PW6 Faizul Haq did not state before me that I have asked Noor Asma while she was going to toilet from emergency ward as to what happened. PW6 Faizul Haq did not state before me that Noor Asma stated to him that the accused Tahir Ali set fire on her by pouring kerosene oil under direction of his father. PW6 Faizul Haq did not state before me that Noor Asma stated to him that she was pregnant. So main by 6, then 7, Shahir Ali. Shahir Ali did not state before me that GMCH Guwahati, he saw that 4-5 persons were bringing Noor Asma from the bathroom of the hospital. And she told before them that her husband, father-in-law and mother-in-law set fire on her. PW7 Shahir Ali did not state before me that prior to the incident, one day he met the deceased on the road and she reported him that she is going to her parental house. PW9 Amjad did not state before me that after marriage of the deceased, the accused person used to torture Nur Asma Begum on demand of dowry, and for this reason, she often used to visit her parental home and villages, settle the matter, and sent her back to her matrimonial home 2-3 occasions. It is not a fact that I have not properly investigated the case and without sufficient material charge sheet was filed. Now, who are the witnesses, madam? Your lordship will be the whose basis, madam? At best, informant. And the whole thing is about the saying that is so-called dying declaration. The persons whose presence is doubtful, madam, in that place. All the persons, madam. Everything was, madam, brought to their mouth through the IOMI. And that person said that 3 kilometers he has gone to bring the company here. Police, we have got it in that miles. Then what is the basis of conviction? Now, my lord, 313, just my lord, what is the defense, my lord? I take to your lordship to page 34. Page 34.
No, but then what is wrong with the evidence of
Now,
PW7?
whether wrong, my lord, who are those, where their presence, it is doubtful, my lord. They are all relative.
You see,
No independent person has supported the case, my lord. None of them, my lord. Your lordship,
where does it say? What does the law say regarding interested witnesses or partisan witnesses?
but your lordship know that
Does it say that it cannot be,
No,
it is
no.
not admissible?
there is no law, my lord.
Then,
Even, but your lordship will see what is the basis. When there is a relative, then your lordship see.
see, there has to be some reason as to how the lady got burnt.
So they kindly see, madam, my statement, what I have stated.
Yeah.
Then your lordship will decide. What I have stated,
What have you stated? How did she get burnt?
kindly see what I have stated, my lord. Kindly see page 34, man. Then your lordship will decide. Page 34, bottom. Question number 13.
Yeah.
On the relevant evening, while I was talking with my 2 colleagues, Muhammad Shahjahan Ali and Karban Ali, in the house of my parent, and at that time my mother offered betel nuts to my aforesaid colleagues. And while we were discussing to attend a village meeting, when we noticed fire in my room, thereafter I tried to enter my room, but the door was hooked from the inside, and I kicked the door, entered into the room, and saw that my wife was burning. Therefore, I brought her to our courtyard and extinguished the fire, and I got burn injury on my right hand. At that moment, my father was not at home, and he returned home from the shop. Thereafter, we shifted my wife to GMCA. My mother also sustained burn injury, I mentioned. We have taken her, and that has come in the my lord IOS.
Where is your burn injury report?
That is not
The doctor's evidence of your burn injury?
that, my lord, that nobody has, this is my statement, it remain, my lord, it is.
If you get burned and you went to the hospital,
But question, I have taken her, that is also come through my IO also, man. We have taken her to the hospital. But my father was not there, my lord. Now all are convicted, my father, mother, and all are convicted. This is the fact, we have taken her. Your lordship rightly questioned earlier, my lord. Why you have not taken? We have taken to the medical college, man.
then where have you stated in your cross-examination to the witnesses that you had taken her to the hospital? Did you cross-examine the witnesses with regard to?
No, that's not necessary, my lord. I am to, because
Why not necessary?
because wife burning case, now I am to say, my lord, what is, and that already it has come in the, just now I have read, my lord. In the IOS opinion. IOPW 910. Page 29, what was it? Yes, man. Page 29. That is IOS, my PW. Tamserali, I'm reading page 29, second paragraph, PW4. Tamserali. PW4. Hamsek Ali during investigation further stated that he, with the help of villagers, immediately sent wife of Tahir Ali by a vehicle for treatment, accompanied by parents-in-law and other 2 persons.
But what does he say in the evidence?
Madam?
PW4.
Yes. PW4 is page photo, hostile. Page, PW4 is page 15. 4 villagers. Independent witness. On the relevant morning while going to church, I came to know that fire engulfed so and so, so and so, so and so. It is not a fact that I put my signature on the seizure. Police recorded my statement at the house of the accused Pandit Ali. At the stage, prosecution declared him hostile. It is not a fact that in my previous statement with the police, I stated that the last night so and so I was going to know that house of Tahir Ali was burning in the fire. Accordingly, along with other people hurriedly arrived. Mr. Tahir Ali was lying at front corridor and bathing indoors.
PW6 has said that this dying declaration given by the deceased.
PW?
6.
PW6,
Page 19
page 1 line.
at the bottom.
This is matter, his present doubtful matter because his name never came matter here. That is problem, that 3 kilometers away matter. It is not supported by anybody matter. He was at all there. Your lordship will find my house is distance of 3 kilometers away.
How does, so what?
Madam, so what means, madam, whether his parents was that, and he said, my lord, that the parents-in-law.
He has a motorcycle, that's why he.
No, I am not on the motorcycle, madam. Right. But what he said, madam, that it has come.
Where is your cross-examination to PW6 that he was not present in the hospital?
That means, your lordship kindly see, my lord. It is not a fact that in my previous statement before the I did not state that Tahir Ali. No, I demanded an answer. It is not a fact that previous statement when I did not say some visited my house. Yes, it is not a fact that in my previous statement before the police, I did not state that Nur Islam had visited my house on the relevant night of the occurrence and requested me to accompany him in my motorcycle to so and so. And he stated that the accused Tahir Ali had set fire on his daughter, so and so. It is not a fact that in my previous statement before me, I did not state that I asked Nur Islam who was so and so. It is not a fact that in my previous statement before me, I did not state Nur Islam stated to me that the accused Tahir Ali set fire on so and so. It is not a fact that I did not state before the police that Nur Islam stated to me that she was pregnant. It is not a fact that I never, it may be I had never gone Nur Islam or something maybe there. Maybe in the original record something maybe there.
There's nothing, there's no suggestion put to him that he was not at the hospital.
But other things your lordship see, my lord. Your lordship can come to from the background of the case, man. Whole thing is, my lord, whether he is present. Father informant says, my lord, that he has gone to taken to them by the parents-in-law. Brother-in-law, they have taken to the hospital. But how he has come to accompany him, my lord?
So what? So just because the in-laws have taken the deceased to the hospital.
We have done our part, my lord. She has.
No, that is maybe to throw off the scent also.
No, that my lord.
So that you see, if you did not go, all the suspicion might lie on you.
That my lord.
But
it is my special case that I found the door is closed. I might have kicked it. I brought her then we took her to the hospital. This is a specific, my point, my case. What else I can do? Man?
This is Pandit Ali. Who is Pandit Ali?
Father,
Father. And you said father was not there.
no, they said father has parents-in-law. Oh, 313, yes, 313, no, my lord, father was not there. At that time, he came subsequently, my lord. That is what she says. For the page, come on, sir. 830, yes, statement. You'll also find page 34, bottom. My father was not at home and he returned from the shop. And thereafter, we shifted my wife to GMC. He came later on, my lord, from the shop. Panditani, my lord, page 38, what Pandit was saying.
You see, you have said, the father has said, while I was returning to my house from the shop, then one Ramjan accompanied me, but he already died. Already died means that lady problem.
So that is die.
So prior to going to the hospital already, he also helped me to arrange vehicle for shifting my daughter-in-law to GMC.
Yes.
So according to the father, the deceased had already died before going to the hospital.
That's why that is
No, already died.
that not denied.
No, denied. Now let us see whether she died at the place of occurrence or in the hospital.
But that, my lord, she was because that also, if she died here, there is no question of dying declaration.
You see, because
Ultimately-
in the 313 statement of the husband,
Husband.
the mother,
Yeah.
nothing stated that she died at the place of occurrence.
Here it is, I have taken courtyard and I have, thereafter I have taken to that year, 34. He said, my lord, only I tried to enter my soul, so I saw that my wife was burning. Thereafter, I brought her to a courtyard and extinguished the fire. And I got burn injury on my right. At that moment, my father so thereafter I got taken.
Project map is PW3, doctor.
PW3. Yes.
Yes.
And doctor there,
Postmortem. Huh?
postmortem report. Time since death is 6 to 12 hours approximately.
Okay.
And
Huh?
he examined on at 2:15 p.m. So
Around
obviously, like,
2:15.
she died in the
The
hospital.
hospital.
Ramzan died, my lord. Ramzan, who accompanied, he died about so far father is gone.
Who died?
Ramzan.
Who is another person died?
No, Ramzan was accompanied him.
So?
So about him, he stated, my lord.
No, but who died? Then you come to page
30,
that
page 42.
Huh?
The Pandit. At that time, page 42, my lord.
Yes.
Pandit
42.
bottom.
Yes.
Time of the incident, while I was choke in a shop,
Yes.
then one child informed me that he heard a poke at my house. After getting the said information, I immediately ran to my house and saw that my daughter-in-law was burning. Thereafter, I arranged for a vehicle. And I, along with my son and other two persons, namely Sadhu Ali and Munjara Begum, shifted my daughter-in-law to GMCA. My son and wife sustained burn injuries while they were trying to save my daughter-in-law. While I was returning to my house from the shop, then one Ramzan Ali accompanied me, but he already died. That is what he announced. He also helped me to arrange vehicle for shifting my daughter-in-law to the GMC.
Anything else?
I think, madam, I do not find anything, madam, subject to what your lordship.
Any citation that are relying upon?
But today, in fact, madam, that's why I immediately asked my lord. I had so many citations. In fact, he told me that I will be taken today, my lord. Since your lordship, the other advocate not there, so I have my lord, instead of wasting time, my lord. If your lordship time, I'll give so many, already it is there, my lord. But
You give me by today, lunchtime, they can go and collect the junior.
today,
Okay. Then we'll hear you. Huh?
Yes.
Call whom? No, we have to hear him. We've got to hear the PP now.
Yes.
I have just gone through the record. I'll try to assess my note. Well, here, PW 1, 6 and 9. From their evidence, my lord, it is clear that my lord, the victim died at the hospital. And from the evidence of PW 1 and PW my lord 7, it is apparent that she was subject to my lord and other witnesses also. Prior to the incident, there was a direct demand.
To whom was the dying declaration given?
My lord, specifically, my lord, PW 1 also said, my lord, and my lord, PW 7, and PW 6, my lord. And my lord, here, 113, my lord, evidence like that presumption will come. my lord. 13B, my lord.
What about PW 8?
PW 8, my lord, the IO, because my lord, there is minor.
PW 8 is not the IO.
My lord, my lord. PW 8 and my lord. Before her also, my lord, she stated.
Then
And my lord, here, because the
what about PW 9?
yes, but I have stated PW 9 also.
So
1, 6, 7,
7, 8, 9.
1, 6, 7, 8, 9.
Okay.
Important, my lord, because the factum that she died of burn injury, they have also not disputed, my lord. And my lord, since she died within 7 years, that presumption will come and it is burden upon them. And my lord, right now I don't have the judgment of a Bombay High Court division bench, my lord. And there, my lord, they have stated, my lord, here that it is upon them to also show what caused her death, my lord. Because at that time, apparently she was at their house. In their 13 also, they have not stated how she died. What happened to her? They simply said, my lord, she died of her own. I will place the judgment, my lord, but this is Bombay High Court division bench judgment. So far, my lord, so far dying declaration is concerned, my lord, I have this one judgment. It, Para 13 may be seen, my lord.
Para?
It starts from para 13, my lord.
Citation possible.
Citation to some 2014.
This was.
2 SSC 81.
CC
2 SSC days 81.
851.
Shall I read or? 13. Before we proceed to scrutinize the legal acceptability of the oral dying declaration, we think it seemingly to refer certain decision regard to admissibility or evidentiary value of dying declaration. So and so has been held that the law is well settled that conviction can be found solely on the basis of dying declaration if the same inspires full confidence. In Ranjit Singh versus State of Punjab, it has been held that conviction can be recorded on the basis of dying declaration alone if the same is wholly reliable. But in the event there exists any suspicion as regards to correctness otherwise of the said dying declaration, the court arriving the judgment of conviction shall look for corroborating evidence. In context, we may notice the judgment of so and so, wherein it has been stated that normally the court, in order to satisfy itself whether deceased was in a fit mental condition to make dying declaration, look up to medical opinion, but where eyewitnesses say that the deceased was in a fit and conscious state to make dying declaration, the medical opinion cannot prevail. Here, when a witness from the witness's statement, it seems that my lord, she was in a condition where she can speak, and she even, my lord, asked for, my lord, water as per the evidence of 1, 6 and 9. My lord. So it shows that, my lord, she was, although she was 90, she was burned very badly, my lord, she was in a mental state where she can speak, my lord. She can speak, and because she was asking water, my lord. And my lord, my learned senior friend has stated that, my lord, somebody has taken from her from bed, somebody has taken her from bathroom. How it doesn't affect, my lord. The factor that she has been burned, my lord, that is there. That has not been, that has not been, my lord, disputed. And the fact that she was in GMCS in ICU, that is also not disputed. Who, my lord, brought her down from bed, who brought her from bathroom, these are immaterial. The second thing is that, my lord, related witnesses, your lordship has already said that I will not burden your lordship, because related witnesses can be relied on. That is an absolute bar, my lord.
So it appears that the only issue is whether we are supposed to believe her
Yes, my lord.
or whether we are supposed to believe the in-law.
In-laws, my lord, but the in-laws, they have failed to state it on what condition, how she has died. And my lord, there the 113B presumption will come. And in that aspect,
Other than
13B of Evidence Act,
113.
113B. My lord, in that judgment itself, my lord, para 15.
forward comes. Please go forward.
But here, para 15 man of that judgment, my lord, I would like to read, my lord. While dealing with evidence of a declarant's mind, the Constitution Bench in Lakshman versus State of Maharashtra has laid down thus: the juristic theory regarding acceptability of a dying declaration is that such declaration is made in extremity, when the party is at the point of death, when every hope of this world is gone, when every motive to falsehood is silenced, and the man is induced by most powerful consideration to speak only the truth. Notwithstanding same, great caution must be exercised considering the weight given to this species of evidence on account of existence of many circumstances which may affect their truth. The situation in which a man is on the deathbed is so solemn and serene is a reason in law to accept the veracity of his statement. It is for this reason requirement of oath and cross-examination are dispensed with, since the accused has no power of cross-examination. Court insists that the dying declaration should be of such nature as to inspire full confidence of the court in its truthfulness and correctness. The court, however, has always to be guarded to see statement of the deceased was not as a result of either tutoring, prompting, or product of imagination. Well, here, see that she was in her parents' house, my lord. The father got the information after she was burned. She was already in a very bad condition, my lord. There was no possibility of tutoring or, my lord, any, my lord, influence, my lord. She was at the hospital, my lord. When they already released, she was in ICU. Nobody, my lord, it is not believable that, my lord, one person will go in the ICU and he will start tutoring, my lord. The normal behavior is, my lord, he will go and ask what happened. So the court also must further decide that the deceased was in a fit state of mind and had the opportunity to observe and identify the assailant. Normally, therefore, the court, in order to satisfy itself whether deceased was in a fit mental condition to make dying declaration, looks up to the medical opinion, but where eyewitnesses state that the deceased was in a fit and conscious state, as I already stated, my lord. To make the declaration, the medical opinion will not prevail, nor can it be said that since there is no certification of doctor as to fitness, this will not come here, my lord. A dying declaration can be oral or in writing, and any adequate method of communication, whether by words or by sign or otherwise, will suffice, provided the indication is positive and definite, my lord. Here, in my humble submission, my lord, her dying declaration was, my lord, as believable, my lord, because there is no scope for, my lord, or time for, my lord, inducement or tutoring. And not only the informant, my lord, other witnesses are also there, my lord. In fact, this, my lord, PW6, my lord, he is not related, man, if I'm not wrong, man. But he's not a related witness also, my lord. And there is no reason for him to, my lord, falsely implicate these petitioners. And my lord, they, as I already submitted, they have in all three 313 statement, my lord, all 3 persons 313 statement, they have failed to show, my lord, on what basis, on how she died. And she died at their house, my lord. So my humble submission, my lord, her dying declaration can be, my lord, basis for this contention. Well, I will place the judgment in the during break time.
That's all.
My lord.
Heard. Mr. H. Khalid Chaudhary, the senior counsel for the appellants. assisted by Mr. A. Mubarak. Also heard Mr. K. R.R. Kaushik, the learned APP. This is an appeal against the impugned judgment dated 12/2/2020, passed by the Sessions Judge Baksha, Mushalpur, in Sessions Case number 218/2018, convicting the appellant under section
Two counts, madam. 302 as well.
2/24 IPC
As well as 304.
and 304 bracket B slash
7 years.
34 IPC. The learned trial court convicted the appellants on the ground that they had burnt the deceased by pouring kerosene on her and sentenced them to undergo
Life under 302.
testament. And sentenced them to undergo a rigorous imprisonment for life with a fine of rupees 2,000 each, in default, simple imprisonment for 6 months under section 302/34. Full stop. They were also sentenced to undergo rigorous imprisonment for 7 years with a fine of rupees 2,000, in default, simple imprisonment for 3 months under section 304B/34 IPC. Both the sentences were to run concurrent. Full stop. Next paragraph. The prosecution case in brief is that an FIR dated 28/7/2016 was submitted by prosecution witness -1 bracket PW1, who was the father of the deceased, to the officer in charge, Korbaha Petrol Post, KAURBAHA Petrol Post, stating that his daughter, who was married to, what do you mean socially married?
Social.
Married
Arranged marriage, madam. Arranged, not love marriage. Other than love marriage, all are social marriage.
Madam, yeah, I think my lord.
marriage also is social marriage.
No, my lord.
No, madam, no,
Initially, subsequently, it culminated into social marriage.
Huh?
madam, social marriage, my lord. I think where these celebrations are the rituals.
I
taking
don't
place.
experience my now, so I cannot say in that
No,
way.
you see, social marriage is what you, either there's a marriage or there's no marriage, that's all.
No,
Whether you are married by a love marriage or you're married by way of arranged marriage, it's a marriage.
love marriage, my lord, social marriage means we go, invitation comes, we go give blessing to them.
But you're married under a particular law, correct?
Love marriage, court, my lord, normally through court, a special court or something.
Doesn't have to be.
Normally what I find, madam. Though I have no experience, like experience, my lord.
Look, I'll just tell you, say for Christians, say in our state, they can be love marriage, there can be arranged marriage, but both of them are married under the church.
Yes.
So,
Marriage, ultimately marriage, both are marriage.
so whether you're married under, there's a love marriage or there is a arranged marriage, for a person professing the Hindu faith, they're married under the Hindu Marriage Act.
Yes.
So it's a marriage.
No, marriage, both are marriage, madam. This way that you're married ultimately.
So social marriage means what? Social marriage is social contract.
No, contract, all the Muslims are contract, my lord.
Ah.
Another aspect.
But then for the Hindus, it will be a
It
sacred
is not a
union.
contract.
It's a sacred
It must be,
union.
ceremony must be there, man.
Ah,
Some ceremony must be, 7 steps must be. But in Muslim marriage, it's not there.
But even for Muslims, there'll be some rituals
No, that is just,
there.
that is only reciting some boxes from the Quran.
That's the
That is the
ritual.
only thing, madam.
That is the
It is not
ritual.
integral part.
That is the ritual. It doesn't mean
No,
that
no, madam,
they're
Muslim,
different. They're
only ijab and acceptance and proposal and acceptance, that's enough.
That's the ritual. That's the ritual. The ritual doesn't have to be going around the fire.
Oh, yes.
Okay,
But Hindutva step, my 7 step must be there.
see, for the Christians, you've got to do it in church. There's a certain procedure. That is the ritual there. That's all. It's
In
different.
Muslim marriage, there is no ritual madam, at all, madam. Simply if I get proposal, I like to marry.
There's no difference.
Say that I agree, enough. Marriage taken place.
There's nothing called a social marriage and a
But that
non-social
is,
marriage.
social marriage, socially, my lord, people go there,
You see,
enjoy it, celebrate it.
see, when you say social marriage, it points to a marriage where the law has not been followed, where there's a live-in relationship.
Basically, what we mean, my lord, other than parents, it is only in between husband and wife, boy and girl, my lord. That is love marriage. Parents, because social marriage, parents come, other come, relatives come, all come. But in love marriage, my lord, they do not come. In between two. This is what is I understand what this is the concept. Unfortunately, I do not have experience for it. This is a problem.
Then a person who doesn't have any experience is trying to give us an explanation.
But I'm giving whatever I find on the rest.
Jail marriage, I think, because where the participation of the reception of society as such, because they invite all the people, they get together.
That is the reception, Mr. Kishore. That is not the
Yes, but
marriage.
usually they refer this as a social marriage, it's not a legal term actually. And here sometimes, my lord, even if they get married, they don't do court marriage. After a long time, they do usually. Yes. So that is the.
We have to gain some experience, I think.
Then why you trying to explain to us something in which you have got zero experience?
On the face of the war meaning, my lord. Only one.
Where were we? Who was married to the appellant number 1, MD Tahir Ali, had been set on fire by pouring kerosene on her, kerosene oil on her. The act of pouring kerosene oil on the informant's daughter had been done by the appellant number 1, appellant number 2, bracket, father-in-law of the deceased, bracket close, and appellant number 3, mother-in-law of the deceased. Correct. Both, all 3 of them had poured kerosene on the which led to the deceased suffering 90% burnt, that eventually led to her death. Full stop. The victim was burnt at around 7:30 p.m. on 27/7/16 and died in the GMCH hospital at around 3:50 a.m. on 28/7/16. In pursuant to the FIR dated 28/7/16, Korbaha PP GDE number 395 dated 28/7/2016 was registered. And thereafter, Tamulpur PS case number 226 16 under section 304 bracket B / 34 IPC was rejected. Next. After investigation of the case by the investigating officer, comma, investigating officer bracket PW 10. Charge sheet was submitted against the appellant on the Ayuk having found a prima facie case under section 302 slash 345, no, 304 dash B slash 34 IPC. Next paragraph. The learned trial court thereafter examined 10 prosecution witnesses, and after examining the appellant under section 3133 RPC, I came to a finding that the appellants were guilty of having murdered the victim. I'm just coming. Due to a demand for dowry. Consequently, the appellants were convicted under section 302/34 and 304B/34 IPC and sentenced accordingly. Next para. The learned counsel for the appellant submits that a separate FIR has been filed against the brother of the appellant number 1 with, correct, na? No. You said,
There is no FIR, Lordship. Only one FIR.
okay, same FIR.
Same FIR.
Then what has happened? No charge sheet has been filed there.
No charge sheet.
So don't, we won't mention it there. Okay, next. The learned counsel for the appellant submits that the conviction of the appellants has been made solely on the basis of the alleged dying declaration made by the deceased to PW 1, 6 to 9. PW 1, 6 to 9. Correct?
6, 7, and 9.
8 also.
8 also, yes. 6 to 9.
6 to 9, huh? However, the said dying declaration has not been made before any, before any magistrate or
Lordship, any magistrate or any medical officer.
any magistrate or any medical officer to have made the same admissible in court as evidence. He also submits that the evidence of the prosecution witnesses are not reliable in as much as there is a discrepancy as to the place where the deceased was found by the prosecution witnesses in the GMCH. While PW 1 had stated that he had found his daughter inside the toilet of the GMC, the evidence of PW 6 7 6 and 7 shows that the victim was not in the toilet of the GMC at the relevant point of time. At the time when they first saw the victim. Further, while the evidence of PW6 is to the effect that he had gone to the GMCH with PW1 in a car, comma. PW7, who is the grandfather of the victim, had not made any mention of PW6 as one of the persons who had gone to the GMCH to meet the victim, along with PW1. Correct?
Yeah.
Anything else? What? Huh? What else? Only on fact. Next para. The learned counsel for the appellant further submits that the that while PW1 had stated that the medical staff of the GMCH had lifted the victim on the table for conducting ultrasound, comma. The evidence of PW 7 was to the effect that he had seen 4/5 persons bringing the victim from the bathroom of the hospital without clarifying who those 4/5 persons were. What else? That's all.
I think while understanding has also raised the point of related weakness.
Full stop. Next para. The learned counsel for the appellant submits that the evidence of PW1, no, the evidence of the prosecution witnesses having been made, the counsel for the appellant submits that the prosecution witnesses being related to the victim, the evidence of the relatives of the victim cannot be the sole basis for convicting the appellant. As they have to be, what, as they have to be.
Interested.
PW6 is.
As they were interested witness.
PW6 is not present.
That's all. I think.
But
That's better. Okay, in support of his submissions, that's better, that the appellant should be acquitted of the charges framed against him. The learned senior counsel has relied upon the judgments of the Supreme Court in the case of Dash versus Dash. Okay. One more thing, just before that, huh? The learned counsel for the appellant also submits that the evidence of PW1 is to the effect that one Raj Ali had apparently informed his co-villager Idris Ali, IDRIS, Idris Ali, with regard to the informant's daughter suffering from burn injury. However, the said Raj Ali and Idris Ali has not been made prosecution witnesses by the police, and neither were they examined during the trial. Huh? Okay, that's all.
MPW 6 and 7 lordship stated, first time stated before the court lordship.
What?
Um,
First time stated what?
I have stated that lordship, PW 10 lordship.
And so I come.
PW 6, 7 is the first time lordship.
Oh. Are you
CW, yellow page 30. Yes. Yes. PW 6, Faizul Haq did not state before me that Pandit Ali harassed deceased Nur Alam by demanding cash and articles. PW 6, Faizul Haq did not state before me that a bichar was held on the demand and harassment of the accused. To Nur Alam, PW 6 did not state before me that Nur Islam had visited his house on the relevant night of occurrence and requested to accompany him in his motorcycle to so-and-so outpost. And he stated that accused Tahir Ali had set fire on his daughter, Nur Islam, by...
Let us see the 161 of this FW.
Yeah.
This PW.
PW 6. And PW 6 say he has gone, my lord, that informant gone at 10 p.m.
So what is wrong?
10 p.m. he's gone and the occurrence 7:30.
So
3 kilometers. I am only presence of PW 6, my lord. I am on only that matter. It makes it doubt, my lord. Presence of 6, my lord. That is, I am only one.
in the village, there's everyone doesn't have motor.
Kilometer, I am not on that. I am only whether he really he was present or not.
3 kilometer in bike hardly take.
He has come at 10 p.m.
3 kilometers will take hardly 25 minutes.
Not.
My lord, at 10 p.m. he has gone. Yellow kind of occurrence is 7:30. And
so what? So what? 10 p.m. You see, for a death, maybe not by vehicle. I have gone at 1 o'clock.
But she was taken immediately to the hospital.
If someone dies at your relative dies at, and this is his daughter.
So my daughter, I have.
Then he has to go to someone who has got a vehicle.
Already vehicle arranged and he is taken to the hospital.
Anyway, that is.
But 10 p.m. He has gone at 10.
Right. Mr. Additional PT on the other hand submits what? What do you submit?
Submission to the higher oral declaration is
Huh?
made up. Our oral dying declaration is voluntary, man, can be trusted.
Submits that the oral dying declaration of the victim was warranted and reliable.
Reliable, and my lord, and they have not explained because
Further, uh, uh, the appellants have not explained as to how
sit down
the victim was burnt and how she died.
inside
the-
their house, man.
In as much as it was their responsibility to explain as to how the victim was on fire.
And my lord, the presumption under section 113 B.
As such, in terms of the presumption under section 113B
B.
of the Evidence Act, the appellant, the appellants, the same implied that the appellants were the perpetrators.
The crime, and my lord,
Right.
demand of dowry is also stated by the witnesses.
Further, the demand of dowry by the appellants from the deceased has also been stated by the prosecution witnesses. And as such, there is no infirmity with the conviction of the appellants under section 304B /34 IPC. He also submits that PW6 is not an interested witness, and his evidence showed that there was trouble in the marriage between the deceased and appellant number 1,
And my lord, related,
due to which village sitting Bichat had also been held.
my lord, and related witnesses, evidence can be
Ah,
relied on. If
so he also submits that
Yes.
even though some of the witnesses were related of the deceased, the same does not bar the trial court or this court from
relying on.
relying upon the evidence of interested witness. In support of his submission that the dying declaration of the victim could be the sole basis for conviction. The learned APP has relied upon the decision of the Supreme Court in the case of so versus 2013 2 SCC 81. Correct?
Yes, my lord. My lord, I have also relied one, I have already mailed, my lord. Yes, my lord. My lord, Achyut Bhaskar Kale versus State of Maharashtra, my lord.
For what?
For, because it is their duty to explain how she died, my lord.
In support of his next para, in support of his submission that it was the duty of the appellants to explain the reason for the victim being on fire and the subsequent death, as the incident had occurred in their house, he has relied upon the decision of the Supreme Court,
My lord, Bombay High Court.
Bombay High Court, decision of the division bench.
Division bench.
Division bench of the Bombay High Court in the case of Achyut son of Bhaskar Kale versus the state of Maharashtra. With there is criminal appeal number 271 of 2014 and the state of Maharashtra versus Achyut Bhaskar Kale, criminal appeal number 325 of 2014.
There are 56. 56. There are 56.
The learned APP also submits that the mental state of the victim was stable. Was stable. In as much
Ask
as
for water and
the victim had asked for water. When asked for water from PW1
PW1.
in the GMC. That's all.
But we have some.
We are waiting for
Yes.
you. When can you give? 2 o'clock. 2 o'clock.
Or if you have, you must be any other case?
No more.
That is-
This is the last.
Only matter what I find on 161. He is also interested, madam, 6. Your lordship kindly see, madam. Mama swallowing. Just a your lordship.
If your lordship require, I can place citation regarding interest services, but I don't think.
No, no, I have, madam, will.
Place, you can place whatever, you have, no problem. You place whatever you want to place.
Two, madam, 2 counts, madam, husband and father and mother. If a total your lordship is not inclined, the husband, maybe put on a 304B, madam. Father and mother, I don't think, madam, did that so much. If I am not, my prayer is, madam, the whole case is not based on any evidence, madam. Because this 6 is also, madam, just regulated on
You
161.
see, one thing, 313, you said that you got burned. If you got burned, you should have at least asked the doctor for some ointment or something.
I have taken her to hospital, madam. What
Then-
I do? That ointment there, madam. I have taken her to hospital immediately, madam. My father came, arranged vehicle, and this 6 has gone at 10 p.m. The was kindly see.
Maybe an interested witness. Which line you were saying that?
Line beginning, I think. Beginning.
Beginning it.
Mama swallowing something is written, madam.
Okay, Mama Swali.
Mama swallow. Sister of his maternal uncle.
Kind of Mama Swali, I don't know that Mama Swali. See. Please sit. Asma Begum. She came to know about the incident. Immediately, day 4 of 2005. And next,
This period is 6 minutes.
means emergency
Okay.
where she was in and then she was
Mama swallow.
speaking out of that now. Then she says that. Specifically, he couldn't say.
What about this, the carrying dowry, did you say anything regarding dowry?
He said that is also.
That is there.
So, but then some.
Okay, okay, state about demand dowry. So this is wrong. So this evidence is wrong. With regard to page 30,
The demand of dowry is also there in his.
That I'm not denying, madam.
did not state before me that the Vichar was there. Vichar was there. No, he said.
Only matter timing, kindly say matter timing. Matter only at what time he has done. Your lordship will find second page in the first 12 p.m. he has done.
Yes, well.
So that you kindly say, madam, whether he is reliable or not. 7:30, we have already sent her to hospital. There is no question of going to his house to bring him to come to the hospital. Already she was sent to hospital. I'm only on that mind.
They arranged for a car and then they went to.
Hello?
They arranged for a car and then they went to hospital.
We have taken her. At 12 p.m. he has gone.
You may, but these people, 4 people, they
Father
arranged,
also, madam.
they arranged a car and then they
At
went.
12 p.m. At 12 p.m. What I am saying. So how she got the she said her madam. By that time she was already operation already there, madam.
No, no,
12 p.m. madam.
In
Really there.
a case of burn, there's no question of operation. There's a question
No,
of
that-
basically.
That not sorry, madam. Some ultra something, some test, something was there, madam. Huh? Ultrasound or something. It has come in there.
Ultrasound.
Oh, that has come.
That time she
I-
died. When she was
12 night.
she died.
At 12 night, whether he has gone there and found her already in the speaking mood, madam, that we all should see, man. He said at 12 p.m. he has gone.
So,
But
That was
7:30
same
occurrence took place, madam.
huh?
7:30 occurrence taken place.
So,
We have taken her to medical college. And at 10 p.m. he has gone to that person's house. Is it believable, madam? Your lordship is to see the probability of that here, madam.
believable. Why? Where is your evidence that you have informed the
Taken-
father of the
Madam,
daughter has been burned?
madam, we have
30 till 12 o'clock you kept quiet. You have not even informed. You have kept quiet.
no, I have taken her immediately, whatever I had to do.
You
I
have
did.
done, but then you see,
Oh.
it is the father of the daughter should have been informed by you.
Already informed, madam, he has already, Already got information, your lordship.
Well informed.
And the taking
I'll
the
show to your
victim
lordship.
to the hospital,
I'll-
taking the victim to hospital doesn't absolve him.
Correct, does
No,
not,
I'm
does
not
not,
saying
does
so.
not prove that he is
I'm saying
innocent.
absolve. I'm saying the conduct of the.
Your conduct, supposing
Uh,
your daughter-in-law, something happens to her. Won't it be your first instinct to inform not only your wife and your son, but also the parents of your daughter-in-law
And to police.
and the police? You
Already,
did
I
nothing.
think that it has come, I will show to your lordship. I think somewhere I have seen my, I'll show to your lordship.
Anyway, let's see.
But alternative punishment is there, madam.
I will-
Oh, madam, we have something to say, madam, because
Okay,
or your lordship, my only prayer is your lordship will decide. My prayer is madam 2 count. So far husband is concerned.
yeah.
At 2
At two, but a short. No.
short.
Bring a judgment at two.
Yes, yes, ma'am.
We are disposing it off today.
Madam. Obliged to your lordship. So, but marriage part will look to see, madam. What?
Yes.
Yes. Madam, your lordship, one query was made.
That is submitted by me, my lord, regarding related witnesses.
Okay.
I'm submitting, just I am
Hold
on.
on. Hold. Hold that, okay.
Not much old,
Huh?
not much old.
2020.
My lord, only one thing, my lord. Just your lordship made a query, my lord. Who has taken, FIR itself says that the accused have taken the to the hospital. FIR itself says. Just your lordship made a query, my lord.
Ah.
So it is an admitted one, my lord. We have taken her to the hospital. That is not dispute because FIR itself says, my. And are you also that you also there? Now the whole question, my lord, whether 302 or 304B or not at all. That is the question, my lord. Your lordship is demanding. So, and evidence your lordship has seen, my lord. Dying declaration all night, my lord. It's opposing dying declaration is correct. But the presence in before whom it was made. Our case with their presence we are doubting, my lord. Presence is still we are doubting. Dying declaration, it is one part. Whether it is reliable or not, it is your lordship to see whether she was in a position to say, my lord. Now, in one case, my lord, we find dying declaration 70-80% my lord burn injury. In that case, court had also, my lord, just it was 70, paragraph what was it? Okay, 25 that is. Wait a minute, I was it. Open the toss in there. 70-80% of the contrast. Just my lord, your lordship kindly see the those on the 2023. my lord. That is what? Oh, that's good. Paragraph 4, my lord. Your lordship what? Which is my lord, 2023 decided on 19/10/23. Paragraph 4 and 15 and 14, 15, 20. Oh,
Yes.
yes. Being aggrieved by the said judgment, appeal came to be preferred on various grounds and primarily on the ground that the deceased has suffered burn injuries to the extent of 70-80%. And she was not in a position to speak. It was also contended that Dr. PW 32, who had certified that deceased was able to speak and had not even recorded the blood pressure and the pulse rate of the deceased in the case sheet, and the retreated doctor PW 31 has also admitted that general condition of the deceased were poor at the time of admission to the hospital itself. It was also argued that evidence which was available before the trial court was not appreciated in proper perspective, and mere dying declaration cannot be the sole basis of the conviction unless it is corroborated. That is the law, my lord, your lordship.
No, then there are other
This is the law.
judgments also.
Now corroborated.
Yes.
Only our cases, my lord, only that what that I am saying, my lord. The person before whom is said, all are interested. And contradictory statement they have made, my lord. Now on the face of it, my lord, then kindly see, my lord, page paragraph 14 and 15. Dowry, because your lordship has put the dowry, it is dowry there. Paragraph 14 and 15. The incidental question that would also arise for our consideration is whether the conviction of the accused under section 304B would be sustainable. The ingredients to be satisfied for convicting and accused for the offense so and so are: the death of a woman should be caused by burns or bodily injury or otherwise than under a normal circumstances. Right one. Such death should have been occurred within 7 years, both fulfilled here. She must have been subjected to cruelty, harassment by her husband or any relative of her husband. Let us assume this is also correct. Then such cruelty in connection, such cruelty harassment is shown to have been meted out for the women soon before her death. This is the question. Now, those statements made, it is general statement, dowry demand, cash money, at that time, immediately after the marriage, madam. That has come in the evidence, madam. Immediately after marriage, not immediately, just soon before the death, madam. I am not saying 1 hour, 2 hours, I am not on that, madam. That's Supreme Court decided, my lord, but reasonably, so, but in the evidence it has come, my lord, that after the marriage, cash demand, that has come, my lord. Then, paragraph 15, my lord. This court in the case of Bansila versus State and so 11 was held that to attack the provision of section 34B, one of the main ingredients of the offense which is required to be established is that soon before her death, she was subjected to cruelty. So, if we say about a dowry death, I think in my humble opinion, 302 is not coming here. 304B best not come subject to what your lordship say, madam. But 304B, my lord, now come to kind of paragraph 20, madam. 20 of the same judgment. Page 20 of the same judgment.
Yeah.
It has been held in Dinesh Sethi Super case. It is quoted, my lord, from that judgment. Section 498A was added to IPC by amending the Act of 46 of 1983. In the backdrop of the growing menace of dowry-related cases in which the women are subjected to cruelty and harassment and are forced to commit suicide. This section lays down that if the husband or his relative subjects a woman to cruelty, then he is liable to be punished with imprisonment of a term which may extend to 3 years and shall also be liable to fine. Exclamation appended to this section defines the term cruelty to mean any willful conduct which of such a nature as is likely to drive the women to commit suicide or to cause a grave injury or danger to life, limb, or health of the women who is such harassment as the wife of beauty so and so, and to have to meet any unlawful demand for any property or valuable security or is on account of failure by her or any person related to her to meet such demand. Then after 3 years, section 304B was inserted by the amendment, paragraph 25. So this 304 was inserted by amendment 43 to deal with the cases involving dowry death. Paragraph 25. That was also inserted subsequently, my lord. That is 1986. Paragraph 25.
25.
Yes, paragraph 25. Yes. After 3 years, section 304B was inserted by amending the Act of 43 of 86 to deal with the cases involving dowry deaths occurring within 7 years of the marriage. Subsection 1 of section 304B lays down that where death of women is caused by any burn or bodily injury or occurs otherwise than the normal circumstance within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband, or in connection with so and so, shall be deemed to have caused her death. By virtue of explanation below, the word dowry used therein carries the same meaning as is contained in section 2 of the prohibition. So my question is, my lord, even 304B, my lord, soon before her death, I take, my lord, all the three ingredients, first one, as it is correct, my lord. Whether, my lord, from any of the evidence set, it is found that it is 2 days earlier, 1 week earlier, or 1 month earlier. They have stated after marriage. The demanded some vichar took place, then she once came back, and then it happened. So this is my humble submission, Lordship, my lord. For interested witness, my lord, whatever, none of them are independent witness. All independent witness have become hostile, my lord. Now, 6 is also your Lordship has seen. Moreover, the timing is very important, my lord. 7:30 occurrence took place. We have taken up the GMC 8. It is admitted in the FIR itself, it is come, my lord. We have taken her to medical college. We have done whatever. And we inform, that also we have come, my lord. We also informed to one of the co-villager. He informed the father of the, my lord, that victim. This is also on the record. You're also questioning whether we have informed or not.
You could have informed. Why should you inform?
But we are busy. We told the other person, just inform him, we are taking her to medical college. But at that time, my daughter-in-law, our daughter, I have come from my shop. I have come, I told one, it has come in that newspaper, that PW1 itself, that inform so-and-so, who informed the daughter. It is just PW1, just one line when I am taking to your lordship. Thief, my lord. Cash money, etc. Subject to physical, mental torture by the accused person demanded motorcycle cash money from her. That is initially. Accused Pandita and Hasina Bibi are the parents. Then torture, but when she was subjected to torture by the accused person in demand of money, she used to visit my house and reported the occurrence to me. Then the accused person, accompanied by the relatives, came to my house and brought back my daughter. One Raja Ali, who is the co-villager of the accused person, informed my co-villager Idris Ali on relevant night of the occurrence that my daughter was suffering burn injury and she was laid on so-and-so banana tree. After getting the information on Idris Ali, I accompanied the folks so-and-so. So that is also admitted, madam. On getting information on our side, he came, madam. So, my lord, in my humble submission, my lord, if at all it comes, so far as husband is concerned, other two, my lord, there is no allegation, my lord. At best, it may come 304B, and that way, my lord, ultimately 498 at 3 years also is maybe converted. This is my humble submission, my lord. And the judgment I have given this one, my lord. Last paragraph, my lord. Last paragraph of this judgment, my lord. Yes.
Lord, may I submit?
For the yes, last paragraph. Yeah. For the reasons stated, for the reasons, my last paragraph, page 31. For the reasons aforesaid stated about the appeal is allowed in part. The judgment and order of the conviction passed by the session judge as affirmed in criminal appeal number so and so. In that case, 7 years was there, madam. Is hereby modified. The appellants are acquitted for the offences punishable under section 304B and section 3 and 4 of aggravation and convicted for the offence punishable under section 306 and section 498A related to section 34 IPC and sentenced to imprisonment for a period already under that. Just I did to your lordship, matter. This is a case where whatever is possible on our part we did, but they could not prove it by independent witness. So I'm relying this judgment matter about the sentence part, man. And conviction also. 2 count, 1 302 life and 304 be 7 years. Both concurrent.
So you are saying that in the alternative,
Yes, man.
304B can be applied.
Applied to in respect to husband matter, if at all. The others two matter, I think subject to your lordship or matter. Other normally in this type of cases, they're automatically roped in these cases, man. All family members. One brother is also in the FIR matter, but he was not charge sheeted. This judgment I realize matter, this one, just now.
That's all.
My gosh.
But that's one thing I'd like to point out, my lord. My senior friend has said that, my lord, that whom those dying declarations were made, my lord. From the witnesses' statement, my lord. Here, because PW 1, 6, and 9, my lord, they said that, my lord, corroborated each other regarding asking for water. The victim was wrapped in a white cloth. These are, my lord, they have witness, and that proves their presence there itself, my lord. So these are corroborative, my lord. Because it's not that only one person has said this, he asked for water. Several witnesses who were present there, my lord, they said the same thing. And regarding this soon before that death, my lord, this is a relative term. It has not it is not a fixed term. That it has to be within 1 month or 2 months. That reason has to be proximate with the cause of death. And here the death was caused, as the dowry, regarding dowry demand, PW6 also said that Bisar was held. One also said, other witnesses also said there was demand. And their presence, in the hospital, regarding that, they didn't cross-examine, neither any suggestion was made, whether you were present or not. All the witnesses. That is my humble submission.
Was the container, the kerosene oil container?
That container, I think it's not my. Fine. Yes, my lord. Empty bottle that smells of kerosene. Empty Maza bottle that is full in 600 ml.
That's all? Yeah, right. The learned counsel for the appellate, submits in the alternative that the appellants can at best be convicted under section 304B and not under section 303.
Applicant number 1.
Huh?
Applicant number 1, I say. Applicant number 1.
Okay.
Husband.
Insofar as the appellant number 1 is concerned. He submits that there is nothing to indicate the presence of the appellant number 2, bracket father-in-law, at the scene of the crime, keeping in view the explanation given during his examination under section 316 CRPC, where it has been stated, the appellant number 2 has stated,
Applicant number 2, my lord, page.
has said that,
Page 40. 40 or also 40.
that
42.
after getting information that there was an uproar in his house, he had run home to his house where he saw his daughter-in-law burning. Thereafter, appellant number 2 had arranged for a vehicle and the appellant number 2 along with his son and 2 others had taken his daughter-in-law to the GMC. Next. He also submits that when the deceased had suffered 90% burn injury, she would not be in a position to speak.
No, just 1 minute. Doctor said 90 to 95%.
90 to 95, but she would not be in a position to speak. concern. He also submits that conviction of an accused under section 304B would be sustainable only if the ingredient required for attracting section 304B IPC is found in the present case, as has been enumerated by the Supreme Court in the case of Parana, Gowda and another versus the state of Karnataka and another. 2023, 7 Supreme, 190. Next. The learned APP on the other hand submit that there is no proposition in law that relatives are to be treated as untruthful witnesses. And on the contrary, a reason has to be shown when a plea of partiality is raised by the defense. In the present case, the appellants have not been able to show that the evidence of the witnesses were untruthful. In this respect, the learned APP has relied upon the judgment of the Supreme Court in the case of Karulal and others versus the state of Madhya Pradesh, criminal appeal number 316 of 2011. That's all?
Madam.
Okay, having said that, now, we have heard the learned multiple times. On a perusal of the examination, on a perusal of the explanations given by all the three appellants in their examination under section 313 CRPC, we find that the appellant number 1, 2, and 3 have given the following reasons. The following have given their take, their take in respect of the evidence adduced against them, which are as follows. Appellant number 1, you take page 34, okay? Page 34, I'm ticking, okay? Then appellant number 2,
Page 38 to 42.
no, page, the appellant number 2 will be page 42. And appellant number 3 will be page 38. Hearing concluded, judgment reserved.
All right, all right.
Single page. How about single page? How about single page? What single page?
Please, your lordship. This IA has been filed for deletion of name, lordship.
Deletion of,
Name of the CAG, lordship, Comptroller and Auditor General of India.
any objection?
CAG was a party in the.
In the main thing, you already a part,
Lordship.
then what is the question?
Lordship, but CAG has no role to play in the
Maybe
any prayer, lordship.
The submission should have been made at the time of.
at that time, now, right now, we'll see. We'll keep it pending for the time. But what about this review? Who has passed, who has, huh?
He is the petitioner and the review petitioner.
Oh,
I am the union. And he has now filed a review, claiming a correction in the case scale. Now, I would just like to point out, lordship, the petition which he had filed, it was allowed in his tender.
correct.
I was a respondent. I prefer the appeal. My appeal was rejected. Similar case, the second one. Petition went against me. Appeal went against me. We went to the Supreme Court. It was affirmed by the Supreme Court. There was a contempt when we have paid the money. Now they want a review of the order passing the writ petition.
Now, how do we reconcile?
Malab, lordship may take up the review petition, malab, defend them, instead of saying,
Huh?
doing this, by closing this IA, actually take up the review petition, malab.
Who's I?
This IA for striking of the name of the.
Yes, this won't be, not at this stage.
Lordship.
Only if we allow the review, can we consider. Not at this stage. At this stage, the review also has not been allowed. Where is the question of this? And then, you see, supposing the review is dismissed, how does it affect?
Lordship, nothing will.
Yeah. You withdraw?
Lordship, will keep it pending, lordship.
No, but you tell me, what is wrong with the order? Well, how that a review is required?
Review, malab, I was led by, malab, senior counsel K.N. Chaudhary. Only for the purpose of this IA, malab, I appear. Perhaps, malab, he's.
For which IA? The IA, this,
Striking of the.
but it says IA with review. It will,
In this review petition number 4, malab, he has filed the IA.
correct.
Striking of.
You let him file by the, but the review is also listed.
Yes, yes.
Where is your case for, say? Where is your case for review? What is the apparent wrong? What is the mistake apparent on the face of the record?
Malab, the subsequent pay scale was not mentioned. And that is why, malab, the initial pay scale
And
they have given.
you file a fresh writ. You file a fresh writ.
Malab, that flows from the, malab, pay scale granted in, with effect from 1/6.
So now you want a revision of your earlier pay scale. Is it?
Initial pay scale was revised. Initial
Then,
pay scale was revised, with effect from 1996.
then,
Subsequent pay scale was not, malab,
so
enhanced.
there's a subsequent revision is required to be made, correct? File a fresh writ. Say that, now it has to be further revised.
I will take instruction from my client, malab, whether he is interested to pursue this review petition or not. Actually, keep the review petition pending or keep the review petition in next week, malab.
I don't think you've got a case. If,
I will talk to my client, malab.
like, Mr. Arcadia said, they have filed an appeal.
Yes, yes,
Dismissed.
that is.
Subsequent, it has gone up to Supreme Court. And
Just
now
to
to
come
come up and open a settled matter Where's the review?
I'll go. Take up the next step.
So this, just show me the file. Both the review.
One review has been closed, mine. The other review has been closed.
Which review has been closed?
That number.
No, all of them, both are open. One is 46, one is 4.
Yes,
You see, because the judgment, the order passed by me
yes.
was based on the order passed by Justice Koteshwar.
Yes.
Correct. So you want a review of my order, which necessitates that the earlier order has to be reviewed.
My lord,
Then there are two reviews.
lordships or the review petition filed against your lordship's order that has been closed by Paras Miller.
I don't know.
Second, do you know what petition is after? To close police second. It should be. So this is filed by the union.
By the Director General.
My-
one, huh?
I also filed a review, my lord, for a petitioner. That review petition was closed by lord. Against the same order.
Show me that order. Show me that order, where the review petition was closed.
It.
Lordship, it seems from the record, Lordship, in the repetition, CSU was not made party, Lordship.
Not made party.
Yes, Lordship.
In which case?
Subsequently, in the review, Lordship, how they have,
Which case?
that the review for Lordship,
That's the other review petition was review petition number 6.
Lordship
my
will
lord.
find in
Which has
annexure
been
B
closed by
page
lord.
11, Lordship.
Show me the order.
Order is not with me, my lord. The review petition is with me, my lord. That was closed by a
A
lord.
review petition 6 of 2020,
My lord, 6 of 2024.
it is against which order?
Against the order passed by your lordship.
Means order passed by. So the order passed by me was with respect to WPC 6603
My lord.
of 2014.
Right.
Correct?
Yes, ma'am.
So the review had been filed by whom?
Review petition number 6.
This column has that was on the ground. The petitioners in the petition, all of them were not similarly situated. 61 of them were liable to get the benefits. The others were
Okay.
for that reason.
And your review against the said order has already been
Closed.
closed. So that's a different issue.
Yep, depends.
Now, so in WPC, okay, so your review is 46. 46 can be taken up.
Yes.
Lordship, my senior Sanjay Kumar Matthew will appear in the item number 2, that is 46. He is not available, he is not right. Fix it up.
Your senior is here.
Sorry.
So what to do?
Lordship will take up this Miras Malad in the next week, my lord.
No, that is one thing. And your case is against the judgment passed
My lord.
by that
Justice
Koteshwar. Justice Koteshwar's case has been, judgment has been challenged before the division bench
My lord.
and before Supreme Court.
Yes, ma'am.
Is it?
Yes, ma'am.
So division bench is clear.
All through it has been upheld. In division bench as well as in Supreme Court.
Justice Koteshwar judgment. This has been upheld. Now what remains? So only 46 is the one that has to be decided.
This is also limited.
There are also only
the review
the fact
petition-
that some of them are eligible, some of them are not.
Both the review petitions will be kept pending, but Lordship will take up in the next week.
Okay, right. On the prayer of the, that's the matter.
This will be-
Not this, I'm not here.
Anybody.
You were it.
That is for correction.
Okay, in this thing, in this, then besides that, in this review petition 4, you just say, Mr. R.K.D. Chaudhary, the learned DSGI submits that the judgment or the impugned judgment and order dated 18/2/2020 passed in WPC 1537 of 2015, which is sought to be reviewed, has been upheld by the division bench and the Supreme Court.
Supreme Court, Lordship, the other case.
Okay, has been upheld by the division bench. Full stop. Further, the judgment and order dated 18/2/2020 passed in WPC 1537 of 2015 had been applied while disposing WPC 6603 of 2015. While judgment and order dated 23/11/21. The said order dated 23/11/21 passed in WPC 6603 of 2014 has been upheld by the division bench and the Supreme Court. As such, there does not seem to be any reason for invoking the provision of review. There does not seem to be any reason to review, any ground for review of the order passed in WPC 1537 of 2015. That's what, okay. Leaves the matter on. You take concrete instruction. Let us dispose it off.
My-
The review, keeping review, it's like a Damocles sword over our head.
On the next day, Lordship will dispatch.
Probably, I don't think you can review it, doesn't, because that
That's the appeal
judgment.
by the apex court. ma'am.
That is settled that we have in fact released on the basis of.
One more thing, Mr. R.K.D. Chaudhary also submits that all the payments to be made in pursuant to that WPC 153 something has already been paid on the basis of the order pass.
First, the second has 61 were eligible. We have released that 61.
Okay. That's okay, that you mentioned. That this is only with regard to this item, this one. Wow, how that one, 15 something. So 61. So the other one is basically, there's a difference between the 61% and the rest 80 or something.
48 petitioners,
48.
situated only 61. 61 we have released, others were not entitled to.
They're not entitled. Yeah.